So let's go to Bumpus. Motion to quash order to show cause. Yeah, that's the hearing on the 25th, where Judge Glanville wants to throw Bumpus in jail for allegedly telling the defense what was going on. Oof. Comes now! That's what. Attorney Kayla Bumpus is the undersigned counsel and files this motion to quash the court's order to show cause filed June 11, 2024, or in the alternative moves this court to transfer this action to another judge or recuse itself as required by law. In support thereof, Attorney Bumpus shows the following. The recitation of the facts. Now we get to hear what might have been going on in that ex parte meeting. Time to pay attention. On Friday, June 7th, 2024, during the trial, the state immunized Kevin Copeland and called him as a witness. Copeland refused to testify. The court placed Copeland in custody over the weekend for his refusal and adjourned until Monday. At this point, Copeland was still sworn as a witness and had not been dismissed. On Monday, June 10th at 8:30 a.m., Copeland and his lawyer, Attorney Kayla Bumpus, were escorted to this court's chambers and conducted an ex parte meeting regarding whether Copeland would testify. I haven't read this before, so you know, this is new for me. I haven't read this. I don't actually know what the allegations or what she claims here. I have no idea. I'm just reading. I'm finding out as you find out. Those present for the substantive portion of this ex parte meeting were Chief Judge Glanville, Copeland, Attorney Bumpus, Assistant District Attorneys Adrian Love and Simone Hilton, members of the court, security staff and deputies. That's a bunch of witnesses. 2 investigators from the District Attorney's Office and a court reporter. In chambers, this court asked Copeland whether he was prepared to testify. Copeland announced that he planned to again invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. So Mr. Steele was right. They discussed ex parte critical things that was happening in the trial, which makes it their business. They should know this. How Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years as he initially believed, Copeland decided that he would testify. That is coercion from the court on this witness. That is coercion. Textbook coercion. Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. Now, she does not claim that Ms. Hilton gave immunity for lying. It might show up later. I don't know. This ex parte meeting was not placed under seal. Ta-da! There was no protective order that directed that disclosure of these ex parte communications was prohibited. How about that? No attorney-client privilege existed. Clearly, as true prosecutors, investigators, a judge, a court reporter, and various court staff were also present. Yes, attorney-client privilege only applies in private conversation between the attorney and the client, which extends to work product, which extends to all information you might find out as you represent the client, whatever its source. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Further, the content of this meeting was not secret, protected, or in any way privileged information. Let's see footnote 2. If there was any privilege, such as a client attorney-client or work product, the privilege would be destroyed with all other parties present, particularly the court reporter. Yeah, she wrote it down. There's a transcript which annihilates any attorney-client privilege. It is unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys of record in the case who are also with fellow officers of the court. Later that same day, defense counsel, Attorney Brian Steele, addressed this court to make a record of his due process concern regarding ex parte meeting. The content of said meeting would not just be non-confidential, but would usually be given to the defense under Giglio and Brady. Yeah. These are, in legal matters, ancient statutes. During Attorney Steele's attempt to put his due process concern on the record, this court began to focus on the identity of the source who, quote, leaked, unquote, the meeting to the defense counsel. The court ordered Attorney Steele to provide the name of the person who divulged the existence and content of the ex parte meeting. Attorney Steele refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action, the attorney could purge himself of contempt if he provided information to the judge, became a criminal contempt action. The court found Attorney Steele in direct criminal contempt. This court sentenced Attorney Steele to the maximum time allowed, which was 20 days to serve in full contempt area. On June 11, 2024, this court entered a show cause order directing all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10th, specifically Copeland, his attorney, Attorney Bumpus, quote, and all representatives of the state and court security personnel that were in attendance, end quote, to show cause, quote, why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to the members of the defense counsel, end quote. This is highly illegal. This should be an emergency meeting for the Georgia State Bar, where they call the prosecutors and the judge to defend their position, in my opinion. No specific names were included in the order other than Copeland and Attorney Bumpus. Arguments. The court seeks to hold in contempt the person that leaked the ex parte meeting to the defense counsel. Thus, the contempt hearing will be about who informed defense counsel whether to find that person guilty of criminal contempt, and if contempt is found, the appropriate punishment. The procedures that the trial court must follow to hold a person in contempt depends upon whether the acts alleged to constitute the contempt were committed in court, direct contempt, or committed out of court, indirect contempt. Here is the thing. An alleged contumacious act may only be said to have occurred in the presence of the court, warranting summary contempt proceeding, if the act was committed in open court, which it wasn't. On the other hand, where the alleged contumacious acts are committed outside of the court's presence, the considerations justifying expedited procedures do not pertain. Thus, summary adjudication of indirect contempt is prohibited. The due process requires that a person who is tried for indirect criminal contempt is entitled to more normal adversary procedures. Among other things, he or she must be advised of charges, have a reasonable opportunity to respond to them, and be permitted the assistance of counsel and the right to call witnesses. And the witnesses in that hearing that Judge Glanville have called is himself. Him. He's in the center of this. But no, he's going to be the judge in that proceeding. Yeah, and then quote this Adams' emphasis in original, quote, disclosing information from the ex parte conversation to members of the defense counsel, end quote, occurred not in open court or in chambers, but at the time and location that defense counsel were notified of the ex parte meeting. So the direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. Here, the need for punishment is clearly not immediate, as demonstrated by the show cause order being set 2 weeks out from the order. So, direct contempt should be out. But this is Judge Glanville's show. he can do whatever he wants until the Georgia Supreme Court drags him out of there. Forms of contempt are further divided into criminal and civil based on the nature of the punishment imposed. Civil contempt is a conditional punishment intended to coerce the contemptor to comply with a court order. By contrast, criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its order. And we saw that on Monday last week when Judge Glanville said that Attorney Steele could purge himself from the contempt if he just revealed his source. So the judge does not know the difference between civil and criminal contempt. After 30 years on the bench, he has no clue, which is scary. The contempt alleged by this court of, quote, disclosing information from the ex parte conversations to members of the defense counsel, end quote, could only be criminal contempt. Nothing can be done to purge or undo that allegations that alleged contemptuous act, and any punishment would amount to criminal contempt. A. No contemptuous conduct occurred. Then neither is, nor was, anything preventing the disclosure of this ex parte meeting to defense counsel. Disclosure did not violate the court order. There is no standing order in place or trial order that bars or in any way limits defense counsel for witnesses or any other individuals present at the ex parte meeting from communicating with defense counsel for the defendants about the meeting and its contents. And here is footnote 4. Even if a protective order were in place that barred participants in the ex parte meeting with a sworn key witness from notifying defense counsel, such an order would deprive the defendants of their due process rights. Ex parte communications are presumed to have been in error. That's not even the bar set. That is the standard. Ex parte meetings, unless justified, have been in error. Yeah, we went through this same thing in the Steele motion. To the extent that this show cause order may be subject to a general demur, the order cannot pass this test. Assuming as true the allegation of disclosing information from the ex parte conversations to members of the defense counsel, contemptuous conduct is not alleged. Furthermore, contempt may be found only where the attorney knows or reasonably should be aware, in view of all the circumstances, especially the heat of controversy, that he is exceeding the outermost limits of his proper role and hindering rather than facilitating the search for truth. Here are more footnotes. Disclosure of the meeting did not exceed the limits of anyone's proper role. If anything, the disclosure facilitated the search for truth. Exactly. A judge may reasonably expect its clerks and other judges to keep what happens in chambers professionally private. However, they are under no legal duty to do so. Such an expectation of privacy does not expend to third parties, not part of the court staff. Yeah, you heard the judge said, the sanctimonious privacy of my chambers. Fuck off! Oh, shit. I said fork, YouTube's. Fork, it's my accent. I say Swedish words and my pronunciations in English, sometimes they sound like other things. A judge may reasonably expect his clerks and other judges to keep what happens in chambers professional and private. However, they are under no legal duty to do so. Such an expectation of privacy does not extend to third parties, not part of the court staff. Holding an ex parte meeting in chambers did not impose a duty of secrecy. Informing counsel for defense of the existence and content of this chambers meeting did not violate any rule of law, trial order, or standing order, and is not the basis for contempt. The show cause order failing to articulate an act of contempt should be quashed. And the Judge Glanville said he will address that after Mr. Copeland's direct examination, which will be, I don't know. And this is the judge must transfer this contempt matter to another judge. We went through this with the Steele motion, so I can skip that. Here, the alleged contemptuous conduct was as expressed by the court directed at least in part towards the court personally and the sacrosanct nature of its chambers. The court became involved in the controversy both by holding the ex parte meeting in the first place and by way of the fact that this court is a witness to the potentially disputed fact of whether there was ever any kind of order to not disclose the meeting to counsel for the defense. Yeah, judge need to show in that transcript. He actually said it. Here's the thing. I don't trust him. He could make shit up. And then Georgia Code of Judicial Conduct dictates recusal because the court's impartiality might reasonably be questioned. We already went through that. I'm interested in more facts here. Here the court's impartiality might reasonably be questioned for 5 reasons. First, this court stated, this is so sacrosanct to have a conversation in my chambers carried to you and others. It is that serious. Revealing that this court views the harm to be at least in part a direct harm to this court personally and or the sanctity of its own chambers. Second, as described in the show cause order, some of the other participants in the ex parte hearing were the court's own security personnel. This gives rise to 2 issues. As potential witnesses, they may testify at the hearing, at which time the presiding judge will have to assess their credibility of the testimony. It might reasonably be questioned that this court would give more credibility to the court's own security personnel than it would to other potential witnesses, such as Attorney Bumpus. Further, the court's own security personnel and reporter like Attorney Bumpus are subject to potentially being held in contempt. These courts impartially might reasonably be questioned if they were to sit as both the prosecutor and fact finder when deciding if it was the court's own security personnel and reporter, someone else who disclosed the meeting. Third, this court has personal knowledge of a disputed evidentiary fact of whether there was an order of any kind barring disclosure of the meeting to counsel for the defense. Fourth, this court appears to already have decided prior to any hearing that it was Attorney Bumpus who made the disclosure. While holding Attorney Steele in contempt, this court stated, whether other than if you, Attorney Steele, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left. And if that person gave you that information or shared that information with you, she probably violated privilege. This judge doesn't understand attorney-client privilege. He just don't, or he don't care. This court's show cause order reinforces this predetermination as the order references no other person present at the meeting by name other than Attorney Bumpus or Copeland. Fifth and finally, the court was visibly impacted when it learned that Attorney Steele had been informed of the meeting. The Georgia Supreme Court referenced an opinion echoing this case in noting when a recusal motion clearly has merit. But what if the motion to recuse has merit? What if the judge who announced an oral ruling is, or reasonably appears to be, partial or prejudiced, and therefore has no business continuing to preside over the case? See Georgia Code, Judicial Conduct, Rule 211. What if, for example, a party defending himself at a contempt hearing turns around and accuses the judge of this, and the judge actively defends himself and then orally holds the accusing party in contempt? Explaining that argument over recusal issues may draw the judge into presenting his side of the story, which in turn may create a perception that the judge is an advocate or hostile witness rather than an impartial adjudicator in the case, requiring disqualification. This alleged contempt is not ongoing and does not require immediate resolution. This court has ample time to transfer this case to another judge who was not involved in the ex parte proceedings, who is not a potential witness to a potentially disputed evidentiary fact, who does not view the harm to be at least in part a direct harm to that judge personally and or the sanctity of the judges on chambers, and who is not called to determine whether that court's own security personnel or reporter committed the alleged contempt, and if so, that punishment to impose. I appreciate it. And Mignola today, and John, and everybody. I don't know how much more I have of this, and then I will scroll through the chat to see if there are any questions I can answer. C. The court must provide a notice that fairly and fully informs the accused of the specific acts of contempt. When a contempt proceeding is criminal, the full panoply of constitutional protections must be afforded the accused. See all these cases. This includes a notice, quote, fairly and fully inform the accused of the specific acts of contempt, end quote. This requirement of reasonable notice in a case involving an alleged indirect contempt contemplates and necessitates a written notice fairly and fully informing the accused of the specific acts of contempt with which she is charged, and so given as to afford a reasonable time to make her defense. Any notice short of that would make a hollow mockery of the fundamental and abiding truth that reasonable notice to one's whose civil rights or personal liberty may be affected is a veritable cornerstone of our judicial system, would constitute nothing more than an exquisite exercise in frustrating futility, sometimes misleading and always meaningless, and would be but sounding brass and tinkling cymbal. A notice in form, but not in substance. And a lot of case law here. As set forth above, the act of disclosing the meeting to defense counsel cannot in and of itself amount to contempt. The disclosure could only potentially amount to contempt if it violated a court order or some other legal duty to not disclose the ex parte meeting. The notice fails to allege any such restriction. As such, the notice fails to fairly and fully inform the accused of the specific act of contempt. Wherefore, Attorney Bumpus would this court to quash its order to show cause, or in the alternative, recuse itself from the proceeding and or transfer his proceeding to another judge whose impartiality can't reasonably be questioned, or in the alternative, provide an adequate notice that fully and fairly informs Bumpus of the alleged contempt. Should all of the above requested relief be denied, Attorney Bumpus requests a certificate of immediate review. And we know that the judge doesn't do that. He refuses to have anything going to the appeals court mid-trial because he is corrupt. Submitted attorneys for certificate of service. Order, this is the judge's order to show cause. Affidavit in motion to recuse Chief Judge Glanville. Let's see here. No, this is just a reiteration of what is. This is just a short form of what we just went through. And okay. So that was Mr. Steels and Ms. Bumpus. And in my opinion, but I'm I'm clearly biased against the judge, so I will have to refer that final decision, hopefully sooner or later, to the Georgia Supreme Court, because this is insane, folks. It is beyond insane that Judge Glanville can have the power to do this.